In this class, we are going to see Criminal Procedure Code. Before going to class, I have posted lectures on entire Evidence Act and also in, in Civil Procedure Code also, and all my previous lectures in Criminal Procedure Code up to section 128 CRPC all are in my YouTube channel, Ilango Ramsamy Advocate, name of the channel. If you want to go through the same, you can go to Ilango Ramsamy Advocate and you can get all my lectures. And also I request you, before watching this lecture, kindly click the word subscribe. இந்த சேனலை நீங்கள் சப்ஸ்கிரைப் செய்யுங்கள். இது பிடித்திருந்தால் லைக் பண்ணுங்கள், கமெண்ட் பண்ணுங்கள், ஷேர் செய்யுங்கள். ஸோ with this, thank you for doing the same. Now I am proceeding to the class. That is already we have seen the scope of previous class, the scope of 125 CRPC, that is the maintenance how to be claimed, then the various aspects, recovery and enhancement, and also how the amount can be recovered. These are the basic things already we have seen. Alteration of allowance and the enforcement of maintenance, that is the 128. Already I have finished up to 128. Now I am going to give some of the citations, important citation. In this regard, whether the marriage for certain aspects, I will read each and every. This is totally only Supreme Court rulings. Claim of maintenance, where wife owns case that husband deserted for 2 years or 3 years after the alleged marriage. The petitioner for maintenance under 125 CRPC has been filed after 12 years after such desertion. The burden lies on the wife to explain satisfactorily of such inordinate delay in filing the petitioner for maintenance. So the wife filed they lived together only for 3 years. After 3 years, the husband deserted her. After that, he filed the maintenance application after 12 years. That is after marriage, totally 15 years, lapse of the 15 years. The petition was filed. Between the desertion and filing a petition, 12 years lapsed. Then the wife has to explain for delay in filing the maintenance. That is the D. Veduchami versus D. Pachiammal, 2011, Criminal Law Journal, page 320, Supreme Court. That is one of the aspects. Then, yet another ruling with regard to wife 125, claim of maintenance by second wife on divorce. Whether the divorced second wife is entitled. Word wife, the word wife 125 1 of includes divorced wife, but if the second wife had not even married, she could not be divorced. A second wife cannot claim maintenance wife of the opposite unless it is established he is not earlier married another woman. So the second wife is not entitled to maintenance if she has been not divorced, but the second wife cannot claim maintenance to be a wife of opposite party unless it is ever he was not earlier married another woman. அவர் வேறு பெண்ணை கல்யாணம் பண்ணின்னு சொல்லி அந்த பெண்ணு தான் நிரூபிக்க வேண்டும். ரெண்டாவது ஒய்ஃப்னு சொல்லி மனு தாக்கல் செஞ்சுட்டு அந்த ஒய்ஃபு claim maintenance, whether the second wife is entitled to maintenance. In that case, the wife has to prove that the husband has married earlier marriage. He did not any earlier married woman to another woman. That is the very same ruling, Veduswamy versus T. Pachiyamal, 2011, Criminal Law Journal, page 320, the Supreme Court. Then, yet another ruling, maintainability of the maintenance application before the family court. Whether a family court is entitled to try the maintenance application. That is, a family court established under Family Court Act shall exclusively have jurisdiction adjudicate the application filed under 125 CRPC. So, the family court is entitled to entertain the maintenance application. That is, குடும்ப நீதிமன்றத்தில் ஜீவனாம்ச மனு தாக்கல் செய்து விசாரிக்கலாம். That is the Sahabanu versus Imran Khan, 2010, Criminal Law Journal, page 521, Supreme Court. Equivalent citation, 2010 1 Supreme Court cases, page 666, and equivalent citation, AIR 2010 Supreme Court, page 305. That is the reported, in several journals it is reported. Then, quantum, grant of maintenance and the quantum of maintenance, that is the one time. Since the husband had earning 10,000 per month as salary, and also he had another source of from agriculture, grant of maintenance to wife at the rate of per month from the rate of application proper. So the 10,000 a person was earning and 1,500 is award, that is the proper, that is Saigo Bai versus Siru Bajirangi, 2011, Criminal Law Journal, page 1007, 1007, Supreme Court. Then whether the divorced Muslim woman is entitled to maintenance under 125 CRPC, that is yet another ruling. In application under 125 by divorced Muslim woman against her ex-husband is maintainable even after Iddat period and as also does not need married. So even before expiry of Iddat period, if she is not remarried, the divorced woman is entitled to claim maintenance under 125. He cannot be restricted for Iddat period only. அந்த இடாட் பீரியடில் மட்டும்தான் கேட்க முடியும், பின்னால் பண்ண முடியாது அப்படின்னு சொல்ல முடியாது. Even after the period of Iddat period, the Muslim woman is entitled to claim maintenance under 125. That is Savanu versus Imran Khan, 2010, Criminal Law Journal, page 521. Then, it a grant of maintenance to woman living together with a man. Here, whether the marriage should be proved to establish the relationship between the husband and wife. திருமணம் என்பதை நிரூபிக்க வேண்டுமா என்றால், question as whether woman living with husband and wife for a long period would be entitled to maintenance, and even strict proof of valid marriage was referred to the larger bench. ஸோ ஒரு கல்யாணத்தை இப்படித்தான் நடந்து சட்டப்படியான மனைவி என்பதை நிரூபிக்க தேவையில்லை. ஸோ லிவிங் டுகெதர் இஸ் எனஃப். தட் இஸ் தி ஜட்ஜ்மெண்ட் given by the Chinmayi versus Virendra Kumar Singh, Guswaha, Criminal Law Journal, page 2011, Criminal Law Journal, page 96, equivalent citation 2011, 1 Supreme Court cases, page 141. Then, at next ruling, 125, legality of declaration of martial status. கல்யாணத்தினுடைய ரெண்டு பேர்த்துக்கு என்ன உறவு, martial status. The claim alleged by divorced second wife. That is the very same case, Veduswamy versus T. Pachiyamal. Very same case is reported. You can. So that is the Then the diverse Muslim can apply for maintenance under 125. Sagima Farooqui versus Sagit Khan, 2015, Criminal Law Journal, page 2551. Equivalent citation 2015, two Supreme Court cases, criminal, page 785. That is the rulings are given. Then 125 maintenance. Order under maintenance is tentative or subject to final determination of status and personal rights of this in a civil court. So the final is tentative and subject to final determination of status and personal right of the parties in civil court. சிவில் கோர்ட் உத்தரவிட்டு தான் அந்த இருவருக்குண்டான உறவு வந்து தீர்மானிக்க முடியும் என்று அந்த வழக்கில் சொல்லப்பட்டுள்ளது. தட் இஸ் நாகேந்திரப்பா நட்கார் வெர்சஸ் நீலம்மா. That is the ruling held AR Supreme Court 2013 1541 page number. That is the criminal adjournment 2013 criminal adjournment 2060 Supreme Court. That is the ruling. Then the purposive interpretation needs to be given to the provision 125. It is bounden duty of the court advance the cause of social justice. That is the Vasa versus Sau Urlima Badusa Cards and others. That is the 2014 1 Supreme Court cases, page 188. And AR equivalent AR 2014 Supreme Court 689. Then how the petition can be ordered from the date of petition or from the date of order, maintenance can be ordered. That is decided by the Supreme Court in Joy Miniben, Harin Bhai Vaishya and others versus Harin Bhai Ramachandra Vaishya and others, 2015 Criminal Law Journal, Supreme Court, page 608. Equivalent citation 2015, two Supreme Court cases, 385. In that case, 125 expressly enables the court grant maintenance from the date of order to from the date of application. Even final order must contain the point of determination, decision thereon, and reason for such a decision should be in place. So whenever a judgment is given, from which date the maintenance has to be paid by the respondent should be mentioned in the judgment. So the date of when the order is passed, from which date the maintenance should be given, that should be given in the judgment by the judges. That is the one of the date. That is the Nandalal versus Vasudo Badwak versus Latta Nandalal Padwak and others. That is the 2014 Criminal Law Journal, page 1098, Supreme Court. Equivalent citation AR 2014 Supreme Court, page 932. That is that case. Then maintenance claim by wife and daughter. That is yet another ruling. They very same ruling. That is Nandalal Vasudeva Badwak, very same ruling as the previous ruling. In that instant case, the plea of the husband that he had no access to the wife when the child was begotten should proved by DNA test report, and therefore the husband could not compelled to bear the fatherhood of child, and the scientific report proved the contrary. That is the way the DNA test, as per the DNA test, the child born to the wife is not that of the husband. The scientific method, DNA test not tally with the husband DNA, hence the court cannot compel to take the parentage of that husband. So the court dismissed the maintenance application. So that is the one of the mode. Then, yet another ruling, date from which it is payable. In the inside Supreme Court was opinion that circumstances require grant of means from the date of application. By so granting, High Court has not committed any legal infirmity. So from the date of application, it was awarded by the High Court. Then there is no illegality passed by the High Court. That is the ruling. Bhuvan Mohan Singh versus Meena and others, 2014, Criminal Law Journal, page 39, 79, Supreme Court. That is the citation equivalence AIR 2014 Supreme Court, page 2875. That is the fixation of quantum. Substantialness does not mean that mere survival. Therefore, quantum fixed C is entitled to lead a lifestyle in the manner as he would have lived with the husband. So, in this case, it was held that the wife is entitled to maintenance. Whereas lifestyle with the husband, if she lives with the husband, what is the lifestyle she are going to adapt? In that lifestyle, she has to pay to enjoy that lifestyle with the husband. The court fixed the quantum of maintenance. That is the இதில் என்ன சொல்கிறாங்கன்னா, அந்த மனைவி கணவனுடன் வாழ்ந்தால் அவருக்கு என்ன அளவுக்கு வசதி இருக்குமோ அதே வசதியுடைய வாழ்க்கை வாழ்வதற்குண்டான தொகையை நிர்ணயம் செய்து நீதிமன்றம் வழங்க வேண்டும். தட் இஸ் தி சகிமா ஃபரூக் வெர்சஸ் சகித் கான், 2015, Criminal Law Journal, page 2551. Equivalent citation 2015, 3 Supreme Court cases, page 705. That is the ruling held by the Supreme Court. So, then maintenance claim by wife under Domestic Violence Act 2005. It would be correct to proceed on the basis of that appellant can continue to be wife of the respondent, so entitled to claim all benefits protection available under Domestic Violence Act also. So the maintenance claim by wife under Domestic Violence Act she is entitled to claim maintenance under Domestic Violence Act. That is the Dioki Panji Yara versus Sesai Bhushan Narayanan Azad and others, 2013, Criminal Law Journal, page 683, Supreme Court. Equivalent citation 2013, 2 Supreme Court cases, 137. That is the equal AIR 2013 Supreme Court, page 346. That is the அந்த வழக்கில் என்ன சொல்கிறாங்கன்னா, அந்த குடும்ப வன்முறை சட்டத்தில் என்னென்ன பரிகாரம் கேட்க முடியுமோ எல்லா பரிகாரம் கேட்கலாம். குடும்ப வன்முறை சட்டத்தில் மெயின்டெனன்ஸ் கேட்கலான்றது அதன் அடிப்படையில் செய்யலாம் என்று அந்த தீர்ப்பில் கூறப்பட்டுள்ளது. தென் where the material and record showed that the respondent has convicted for offence of bigamy due to second marriage, but the appeal against the conviction was pending at the relevant time. It cannot be said the appellant was saying separately without any justification that the appellant wife was entitled to maintained by the husband. So in that case, the husband got second marriage and he was convicted and he was inside jail. It cannot say he was living separately without any such. The husband stated that he is not living separately due to the conviction only he was inside his jail. but the lower court and the Supreme Court rejected the plea of the husband. The appellant wife is entitled to maintenance by the respondent husband. That is the then அந்த மாதிரி ஒருத்தர் வந்து நான் ஜெயிலில் ரெண்டாவது கல்யாணம் பண்ணி ஜெயிலுக்கு போயிடுறாரு. ஜெயிலுக்கு போன ஒருபாடு ஜெயிலில் இருந்த காலத்தில் மெயின்டெனன்ஸ் கேட்குறாங்க. நான் ஜெயிலில் இருந்ததுனால நான் வேணுமென்று பராமரிக்க தவறுங்க, அதனால் மெயின்டெனன்ஸ் கேட்க முடியாதுன்னு சொல்ல முடியும் என்றால் அது அது சரியில்லை என்று சொல்லி ஒய்ஃபுக்கு நீங்கள் ஜீவனாம்சம் கொடுத்தாகணும்னு சொல்லி அந்த தீர்ப்பு கூறப்பட்டுள்ளது. inability to maintain herself, அவர் தன்னைத்தானே பராமரிக்கக்கூடிய முடியவில்லை என்பதை நிரூபிக்க வேண்டும். So inability to maintain herself is a precondition for a grant of maintenance to wife. That is the you have to state, you have to aware in the petition that if the wife is not able to maintain herself, these are the inabilities. So she is not able to get any amount for her livelihood. Only the income from the husband, that is the maintenance, can be affordable to maintain leave. Then the court will give grant maintenance. So that is the economic condition is good. The husband, wife, and wife would be entitled to maintain. That is the ruling. Sunita Kanchawala and others versus Anil Kanchawala, 2015, Criminal Law Journal, page 659, Supreme Court. That is the ruling. So when the plea is raised by husband, the wife is earning on that ground alone, whether court can dismiss the maintenance certificate. That is the rejection of validity. Nothing was placed on record either before the Common Court or High Court to prove that her employment and her earning. So the wife employment and earning was not proved to the husband. Then in any event, merely because wife was earning something, you would not be a ground to reject the claim of wife சம்பாதிக்கிறாங்கன்னு ஒரே காரணத்துக்காக அவருக்கு ஜீவனாம்சம் தர கூடாது என்று மறுக்கக்கூடாது. That is the Sunita, and that is the ruling held by the Supreme Court. Then object நோக்கம் என்ன, 125 நோக்கம் என்ன. When the husband denies that the application is not his wife, all that magistrate has found that in a person and his wife is whether there were some marriage ceremony between the parties, when they were lived as husband and wife in the eye of law of their neighbors, whether the children was born out of the union. So the husband take a pity that she is not my wife. கணவர் என்னங்கிறார், அவன் மனைவியே இல்லைன்னு சொல்கிறாரு. Then the magistrate has to find the நீதிபதி என்னத்தை பார்க்கணும்னா, whether they have lived together or whether there was some marriage ceremony between the parties. அவங்களுக்குள்ள திருமணம் இருந்து சொல்லியிருக்காங்களா, அதை பார்க்கலாம். Whether they lived as a husband and wife in the eye of law, பார்த்து அண்டை அயலார் வீட்டு கண்ணுக்கு போனால் கணவன் மனைவியாக ஏதாவது வாழ்ந்துருக்கிறாங்களா, அவங்களுக்கு எதாவது அந்த வாழ்க்கையில் ஏதாவது குழந்தை பிறக்கிறதா அப்படின்னு இந்த சூழ்நிலை. These are the circumstances the court can consider to grant maintenance to wife when the husband disputed the wife is not wife, whether any marriage is some marriage ceremonies are given by the wife, or whether any evidence or document evidence to show that they are lived together as husband and wife, and whether they out of the relationship living together any child is born out of them. If any one of the condition is present, then the court can grant maintenance. That is the ruling held by Munnibai, and the ruling held by Pyal Muttayammal alias Satyavati versus Pyal Sri Demu and others. 2012 Criminal Law Journal, page 660, Supreme Court. That then it cannot be said then payment of maintenance. Another ruling. Uh, the appellant was staying separately without any justifiable reason. She should be maintained by her husband. So that is the ruling. Munnibai versus Banwari Lal and another 2016 one Supreme Court cases, page 621, are equal on AR 2016 Supreme Court cases 2224. That is the ruling citation. Validity of marriage will not be a ground for refusal of maintenance. அந்த திருமணம் செல்லாதுங்கிற அடிப்படையில் ஒரு ஜீவனாம்சத்தை தர மறுக்கலாமா? Then having thus considering contrary version consisting parties and deliberation deliberate over the argument advanced by in the light of evidence, and the court clearly read that irresistible conclusion. அது முடிவுக்கு வருகிறது. ரெண்டு பேர் இருக்கிற ஆர்குமெண்ட்டை கேட்டுட்டு that the High Court wrongly exercised jurisdiction while entertaining the division in the order of granting way to appellant wife. தட் இஸ் தி அந்த இடத்துல ஹைகோர்ட் தப்பாக பண்ணியிருக்குது அப்படின்னு சொல்கிறாங்க. தி வெரி சேம் கேஸ் பியாலா முட்டாயம்மாள் அலையாஸ் சத்யாவதி, தட்ஸ் எ வெரி சேம் ரூலிங், ப்ரீவியஸ் ரூலிங். Then on the basis of retirement, whether the maintenance can be reduced to 50%. Solely because the husband has retired, there was no justification to reduce alteration of maintenance, to reduce the maintenance by 50%. That is the Shamima Faruqi versus Sagid Khan, 2015, Criminal Law Journal, page 2551. Then once children attain the majority, the provision 125 would cease to be applicable in their case. That is Amarendra Kumar Pal versus Maya Pal and others, 2010 Criminal Law Journal, 395 Supreme Court. Then yet another ruling latestly given by our Madras High Court. Kiruba Kanmani versus L. Rajan. It was held that a person after attaining the majority is entitled to unmarried daughters. That is the petitioner who is aged about 18 years. In unmarried daughters, respondent has sought maintenance from the father on the ground she is not in a position to take care of expenses incurred by her towards the education. ஸோ ஒரு கல்யாணமாகாத பெண் என்னால் படிக்க முடியல அப்படின்னு சொல்லி ஃபாதர்கிட்ட மெயின்டெனன்ஸ் கேட்குறாங்க. Then it was held that the High Court has held that in that ruling, Section 20 of Hindu adoption maintenance is very clear. The father is under obligation to maintain his unmarried daughter even she has attained the majority. 125 is contrary, whereas an unmarried daughter even after attaining the majority, according to Hindu Adoption and Maintenance Act, even major unmarried daughters is entitled to maintain. The council, in order to substantiate arguments and relied upon the Supreme Court judgment, that is the Nuru Shaba Cartoon versus Muhammad Qasim, reported in 1977, page 6th volume, Supreme Court cases, page 323. In that case, it was held the Muslim woman is entitled to maintenance. That is Then yet another ruling, it was Jagadish Jagatwala versus Manjula Lata and others, reported 2002, 5 Supreme Court cases 422. On the basis of these two rulings, the court held that the and also yet another ruling, Mansi Ohara versus Ramesh Oharaj, reported 2012 Supreme Court cases online and dedicate 1535. And on the basis of these rulings, and 2016, yet another ruling, T. Vimala versus and others, S. Ramakrishna, reported in 2016 Supreme Court online, Madras, page 12, 324. In all cases, it was held that on the basis of these reports, the finally court held that the criminal petition allowed order passed by law it is set aside and they are directed to represent the petition. The lower court fails to entertain the application since he is a unmarried daughter. Then she is not entitled on attaining the majority. It was elaborately discussed in that case. And in the year 2000, and it was the judgment is held on 17th June 2019. Justice Anand Venkatesan of our Honorable High Court, Madras, and in that ruling it was clearly held that even unmarried daughters, that is R. Kiruba Kanmani versus L. Rajan, is entitled to maintenance. That is the ruling. Then payment of entire maintenance execution. The order dated 21/4/2004 High Court set aside and the court now issued a direction to the respondent to pay entire maintenance due under application within the period of 6 months. In the above order, this court is not complied with by the respondent. The learned trial that is directly issue warrant for arrest and ensure that same should be executed. The respondent taken to custody suffer imprisonment proved under section 123 of CRPC. So in that case, when the respondent fails to pay the maintenance amount, the lower court was directed to issue warrant and commit him to inside the jail. That is the order. Pungodi and another versus Tangamal, 2013, 10 Supreme Court cases, volume 10, Supreme Court, page 618. Then equivalent citation 2013 Criminal Law Journal, page 5006, that is the Supreme Court, that is the order of the Supreme Court. A criminal procedure code which regulates the criminal interview and arrest and detention is a means for enforcing financial liability. So the criminal court, whenever wants to get the ஃபைனான்ஷியல் லைபிலிட்டிஸ், இந்த மாதிரி பணம் கொடுக்க வேண்டியது இருந்தால் கைது செய்து உள்ள வைத்து உத்தரவிட வேண்டும் என்று சுப்ரீம் கோர்ட் உத்தரவிட்டுள்ளது. தட் இஸ் தி ஃபைனான்ஷியல் லைபிலிட்டி காஸ்ட் பை தி கோர்ட். இப்போ ஒரு நீதிமன்றம் உத்தரவிட்டு ஒரு தொகை செலுத்த வேண்டியிருந்தால் அவரை கைது செய்து சிறையில் அடைக்க உத்தரவிட வேண்டும். தட் இஸ் தி சுபத்ரா ராவ் சகாரா வெர்சஸ் யூனியன் ஆஃப் இந்தியா அண்ட் அதர்ஸ், AR 2014 Supreme Court, page 3241, and also equivalent citation 2014 volume 3 Supreme Court cases criminal, page 712. That is the various citations of the Supreme Court. And whether the physically fit, that is the one of the ruling, obligation on the of the husband to maintain wife and children. In fact, it is duty render financial support. Even the husband is required to earn money with the physical labor. If he is able-bodied, then there is no escape route unless the order from the court to the wife is not entitled to maintenance and legally permissible ground. So when the legally ஒரு வந்து சட்டப்பூர்வமாக ஜீவனாம்சம் செலுத்த வேண்டி இல்லை என்று இல்லாத சூழ்நிலையில் மட்டுமே ஜீவனாம்சத்தை தர மறுக்க வேண்டும். ஒரு கணவர் அவர்னால் சம்பாதிக்க வழி இல்லை, ஆனால் உடலெல்லாம் நல்லா ஆரோக்கியமாக இருக்கிறார் என்று இருந்தாலும் அவர் மீது ஜீவனாம்சம் வழங்க கொடுக்க உத்தரவிடும். தட் இஸ் தி வென் ஹஸ்பண்ட் இஸ் பாடிலி ஏபிள்டு, is of sound healthness, then the court can grant maintenance to the wife unless there is any prohibition against the wife, there is any hindrance against the wife to pass maintenance. Otherwise the wife is entitled to maintenance even the husband is not earning. It is proved that he is bodily able person. That is the Bhagavan Mohan Singh versus Meena and others, 2014, Criminal Law Journal, page 3979. ஒரு கணவர் வந்து நல்ல தடயமாக்கி ஆரோக்கியமாக இருந்தாலும் நிரூபித்தாலே போதும், ஒய்ஃபுக்கு வேறு ஏதாவது வழியில் ஜீவனாம்சம் தர வேண்டியதில்லை என்று சட்டப்பூர்வமான தடை இருந்தால் மட்டுமே அதை வந்து கொடுக்க மறுக்கணும். இல்லாட்டி கணவர் சம்பாதிக்கல அப்படிங்கிற ஒரே காரணத்துக்காக நல்லா ஆரோக்கியமாக திடகாத்திரமாக இருந்தாலே ஜீவனாம்சம் தீர்ப்பு வழங்கலாம். தட் இஸ் தி ரூலிங். தட் இஸ் தி கிரிமினல் லா ஜேர்னல், பேஜ் 2014, கிரிமினல் லா ஜேர்னல், பேஜ் 3979, and the equivalent citation AR 2014 Supreme Court, page 2875. That is the ruling. So that is bodily able, that is the so these are the various citations in the Supreme Court with regard to maintenance. Then some important old, even though I have noted some important rulings. That is the term living in adultery. Meaning of it, to establish fact of adultery, it should be established that wife is habitual in committing acts of adultery. Vague allegation of adultery is not isolated act on the part of wife will not adversely affect the claiming maintenance. ஒரு பெண்ணை வந்து ஒருத்தவங்க கூட ஒரே தடவை போனால் அப்படிங்கிறத வச்சு ஜீவனாம்சம் மறுக்கக்கூடாது ஒரு சிங்கிள் ஆக்டில். தட் இஸ் 1991 கிரிமினல் லா ஜேர்னல், page 675, volume 2. So the second volume in criminal law journal. Then husband denied the responsibility on the ground that the time of marriage, his first marriage, was subsisting. Husband failed to establish his earlier subsisting marriage between the appellant and husband performed according to Hindu rites. The respondent was bound to prove that the earlier marriage was in customary form and subsisting on the date of marriage. Wife, the appellant being a lady, wedded wife, is entitled to maintenance amount per month. That is the 1991 volume 2 criminal law journal, Supreme Court, page 364. That is the yet another ruling. So the maintenance refused by wife to stay with her husband in spite of decree for restitution of conjugal rights. Decree for divorce passed on the ground that the decision wife is not entitled to the findings of the decision by civil court binding on the magistrate court also. 1995 criminal law page 108. That is the one of the ruling. So father mentally deranged woman due to cruelty inflicted by husband is entitled to may claim maintenance on her behalf against her husband. In this case, a mentally affected lady, on behalf of mentally affected lady, the father filed a case against the husband. Then the uh, mental deranged woman, that is the act harassment given by the husband, then the that lady is entitled to the her father is claiming on behalf of the lady. That is valid. That is the 1993 Law Weekly Criminal, page 283. So when the ex parte order for restitution of conjugal rights in a maintenance court, not a bar for wife to claim maintenance, that is the 125, and directly issue, that is the ruling. Then directly issue warrant for realization of already maintenance and is under order sentencing to imprisonment are illegal. That is 1991 Law Weekly Criminal, page 129. Then important decision. You have to note 1995 1 Madras Weekly Notes, page 235. Petition for additional maintenance, lump sum amount payment of rupees 3000 by her husband to his wife towards the lifetime maintenance, not sufficient for her till her lifetime, when especially she happened to be a young woman in earlier 20 years. Held wife is entitled to additional maintenance due to change over the circumstance. இந்த வழக்கில் என்ன சொல்கிறாங்கன்னா, ஒரு லம்சம் அமௌண்ட்டை கொடுத்து ஆயுள் ஜீவனாம்சம் கொடுத்து எழுதி ரிஜிஸ்டர் பண்ணி வச்சுருந்தாலுமே ஒரு 10,000 கொடுக்குறாங்க. இன்னும் 30 இயர்ஸ் முன்னால் 10,000 கொடுக்குறாங்க. அதை வாங்கிட்டு ஆயுள் ஜீவனாம்சம் எழுதி கொடுத்துறாங்க, இனிமேல் கேட்க மாட்டாங்க. ஸோ வெதர் தி ஆஃப்டர் 30 years her living style cannot be met with that 10,000, then she can file a fresh maintenance application. That is the ruling. Madras Weekly Notes, page 235, 1995, first volume. That is the ruling. Held that ஒரு பெரிய அமௌண்ட்டை கொடுத்து ஒரு அந்த காலத்தில் அது பெரிய அமௌண்ட்டாக இருக்குது. ஒரு 20 வருஷம் கழிச்சு இப்போ பார்த்தீங்கன்னா இப்போ வந்து ஒரு 3 lakhs கொடுக்குறாங்க. ஆஃப்டர் 20 years பார்த்தீங்கன்னா 3 lakhs ஒன்றும் இருக்காது. இப்போ வந்து 85ல் ஒரு 1 lakh கொடுக்குறாங்க. இப்போ பார்த்தீங்கன்னா 2020 அந்த 1 lakh வச்சு வட்டிக்கு பேங்க் வட்டி வந்தால் 1000 ரூபா தான் வரும். 1000 ரூபா வச்சு ஒரு பெண் குடும்பம் நடத்த முடியாது. அதனால் அந்த 1,00,000 பத்தாது, இப்போ நான் தனியாக மெயின்டெனன்ஸ் கேட்குறேன்னு போடலாம். தட் இஸ் தி ரூலிங். தட் இஸ் தி செகண்ட். Even the lump sum settlement was paid by the husband, that the lump sum amount cannot meet out the expenditure after lapse of long period, then the wife can change of circumstance and the values of the rupees, and she can file a fresh maintenance application even though he relinquished her lifetime maintenance. That is the ruling held. So these are the some of the basic rulings with regard to maintenance. Then you have to take down some of the important rulings. So appellant is husband of the respondent, having two children. During the subsistence of marriage, appellant married the sister of his wife and left home. Maintenance petition filed by the wife. Trial court awarded 1,000 rupees per month towards maintenance. Hence, this appeal by the husband. Appellant, the husband raised leveled allegation against wife having illicit relationship with the neighbors. But she got married, the sister of the wife. Then the allegation not proved. The appellant in government service, apart from he is earning income from other sources, hence appellant liable to pay maintenance. That is the T.G. Gopalakrishnan versus G. Rajamal alias Money, 2018. Tamil Nadu Law Reporter, page 308. That is the ruling. Then it was held that the maintenance right which accrues to wife against her husband, the minute farmer gets married to later, it is only a moral, it is not only a moral, but it is a legal duty. So maintenance right is not a moral obligation, it is a legal duty. மனசாட்சிக்கு பிரகாரம் கொடுக்கறதில்ல, சட்டபூர்வமான கடமை. தட் இஸ் தி மாரல் ஆப்ளிகேஷன். பரிதாபப்பட்டு அடட அப்படின்னு சொல்லி கொடுக்கறதில்ல. மாரல் ஆப்ளிகேஷன், கடமை இல்லை. இட் இஸ் எ லீகல் டியூட்டி, சட்டபூர்வமான கடமை. ஸோ மெயின்டெனன்ஸ் ரைட் இஸ் எ லீகல் டியூட்டி, நாட் மாரல் ஆப்ளிகேஷன். தட் இஸ் தி சைல்குமார் தேவி வெர்சஸ் கிருஷ்ணா பகவத் பதக் அலையாஸ் குஷன் பி பதக், 2009, 1 MLJ, criminal 899 Supreme Court. That is the ruling. Interim maintenance. The matrimonial court can take note order passed by 25 not purpose of arriving at interim maintenance. Amuda alias Satya Shyamala Devi versus Tirumurthy alias Tirumalai 2009, 7 MLJ, page 1050, Madras. Illegitimate child. Right of maintenance. Supreme Court has held that an illegitimate child is entitled to maintenance from his father. That is Timbal Gupta minor versus Rajiv Gupta, 2008, 1 MLJ criminal and MLJ criminal, page 1476, Supreme Court. Equivalent citation AR 2008, Supreme Court, page 239. That is the ruling. DNA test, pendency of maintenance. The order of DNA test should be made by the court exercising its discretion. Only the application strong prima facie there is sufficient material before the court. That is whether DNA test can be ordered. That is the Prem Kumar versus Rajeshri, 2009, 2 Law Weekly Criminal, page 1324, Madras. Then It has been held that living wife is in living relation would be entitled to maintenance if deserted even they have not attended valid marriage and terms of Hindu law. இந்து திருமண சட்ட பிரகாரம் திருமணம் முறைப்படி நடக்கவில்லைனாலும் ரெண்டு பேர் ஹஸ்பண்ட் அண்ட் ஒய்ஃபாக வாழ்ந்தால் போதும். சின்மயாமி வர்சஸ் வீரேந்திர குமார் சிங் குஸ்வால் 2011 1 CTC page 101 Supreme Court. Ex parte order of trial court directing the husband to pay maintenance to 5,000 monthly installment to wife. Revision against the husband paid to 20,000 to the respondent wife's maintenance not disputed. Order passed by 125 is neither order of acquittal nor conviction. In law, revision on the husband application, trial court can modify, recall, even review the ex parte order of maintenance order. In the circumstance required, it is open to the revision to file a necessary application for seeking modify and recall and ex parte order. Hence, revision petition to file a petition appropriate and open to file. And the ex parte order was granted. The trial court directed the ex parte order set aside petition can be filed by the husband. Within 2 months, it can be disposed of. That is the ruling given by S. Senthil Kumar versus S. Nachal 2013. 1 Tamil Nadu Law Reporter, page 47, Madras. Maintenance appeal against. When the assessment of lower court could be reasonably sustained, the decision not to be interfered. Simple reason, even assuming the husband has not got any grievance in the interim maintenance by the below the court proceeding, he is liberty to work out his right provided under 125 CRPC. That is V.M. Subramaniam versus Nagamani 2007 3 CTC page 240. Then, while awarding maintenance under section, the High Court now is bound to examine the factual position. In the present case, husband and wife having admitted the marriage but the birth of the child to them conducted the marriage between them is illegal and void, as his first marriage was not dissolved. First marriage was not dissolved. Hence, no particular regarding the first marriage took place and which place burden lies on the husband. It is open to get declared his status by civil court of family. That is the Vachai and another sources Palniyappan 2008 1 Madras Weekly Notes criminal page 98. Claim by divorce. Whether there is no evidence to show that the divorced wife have sufficient income to maintain herself, he would be entitled to give maintenance. இந்த மாதிரி அந்த விவாகரத்தை பெற்ற மனைவிக்கு போதுமான பணம் இருக்கிறது, வசதி இருக்கிறது என்பது நிரூபிக்கப்படாத பட்சத்தில் அந்த பெண்ணுக்கு ஜீவனாம்சம் வழங்கலாம். தட் இஸ் தி if marriage is nullity or not recognized by law, wife cannot claim maintenance unless the marriage declared to be competent civil court. The wife is entitled to claim maintenance from her husband. Burden is on the husband to that there was a divorce between himself and his wife. Unless plea of divorce is established before the wife, first wife is entitled to claim maintenance and the court rightly granted by the wife. No interference. That is Ganesan versus G. Puspa 2018 1 Tamil Nadu Law Reporter page 142. So these are the marriage of woman in accordance with Hindu rites with a man having living spouse is completely nullity. Such woman is not a wife expressed. However, illegitimate child is entitled from her husband. That is the if the magistrate is a prima facie satisfied with regard to performance in proceeding which is summary nature, Strict proof of performance of essential right is not required. That is Rahiman alias Pyari versus Kumari 2001 Madras MLJ criminal page 547. So, yet another ruling DNA test report excludes the paternity of the in respect of child, which presumes that the first respondent wife was leading adulterous life. Hence, as per the section 124, 125 subclass subsection 4, it was held the respondent and wife children are not entitled to maintenance. That is M. Ramakrishnan versus R. Manjula and others, 2011 3 MNJ, criminal, page 639. When the order was set aside on the ground of territorial jurisdiction, that is not valid ground. Hence, the order revision was unsustainable. Um, Mogana Bal versus Annadurai 2011, 2 Madras Weekly Notes Criminal, page 418. Equivalent citation 2011 4 MLJ Criminal, page 13. So, these are the important judgments with regard to 125 to 128. Then, this I conclude my class. The maintenance chapter is over. We can see next chapter from next class onwards.